Today I'm going to talk to you about going to court for summary charges in Queensland. If you've been charged with a criminal offence in Queensland, the first court you'll appear in is the Magistrates Court. The criminal offence you're charged with will determine where it is finalised. For example, some criminal offences are finalised in the Magistrates Court, while others go to the District or Supreme Court. I'm going to discuss with you the process for criminal offences when they are finalised in the Magistrates Court. You'll hear a phrase called the QP9 court brief. When police charge a person with a criminal offence, they'll prepare a document called a court brief, commonly referred to as a QP9 court brief. This is one of the first documents a criminal lawyer will want to see before they give you any advice in relation to the offence you're charged with. A criminal lawyer will want to see this document because it sets out various things of relevance. 1. The offence you're alleged to have committed. 2. The date of the alleged offence. 3. The facts alleged by police that they rely upon to say you committed the offence. 4. Any damage police allege you caused. 5. If police say you cooperated with them during the course of their investigations. If you have a criminal lawyer representing you, they should ask the prosecution to give them a copy of the QP9 court brief before your court date. By your lawyer having this document before your court date, it can help determine what may happen with your case. If you only get the document on the first court date, it'll likely be that your lawyer will need an adjournment so they can review the court brief and give you advice about it. For most cases finalised in the Magistrates Court, the QP9 court brief is the only document police prepare in relation to offence a person is charged with. You may wonder who hears criminal cases in the Magistrates Court. The person who hears or decides cases in the Magistrates Court is called a magistrate. If you plead guilty to a criminal offence, it is the magistrate who will decide on the penalty you receive. Likewise, if you go to trial, it's the magistrate who will decide if you are guilty or not guilty of the criminal offence. There are no juries in the Magistrates Court. It is solely the magistrate who decides your penalty and whether or not you're guilty or not guilty of an offence. Mentions in the Magistrates Court. Now, what are they? When you first go to court for a criminal charge, this is called a mention of your case. Unless you plead guilty and are sentenced at the first mention of your case could have several mentions. A mention of a case refers to when a magistrate reviews a case in court. The prosecutor and defendant and/or defence lawyer appear in court. The magistrate wants the prosecutor and defendant to tell them how they wish the case to proceed. There are many different things that can happen at a mention, and I'll explain these now so you have an understanding. 1. You may ask the magistrate for your case to be adjourned for a mention to another court date so you can get legal advice. 2. If you have a lawyer acting for you or representing you, your lawyer may ask for your case to be adjourned for a mention to another court date so they can get instructions from you and have a chat with you about your case. 3. You or your lawyer may ask for your case to be adjourned to another court date to allow the prosecution time to disclose, that is, give you material. For example, you may want copies of witness statements or other pieces of evidence before you decide what you want to do with your charge. 4. You or your lawyer may ask for your case to be listed in order for you to be sentenced for the offence, or for your case to be listed for trial. Now, do you need to go to court when your case is being mentioned? The answer to this question is not straightforward. Whether or not you go to court will depend on a few things. 1. If it's the first time your case is being mentioned in court. 2. If you've already been given bail by the police. 3. If you are legally represented and your lawyer is going to be at court. If it's the first mention of your case in court, you generally need to attend court. However, there are exceptions to this rule, which I will explain. If you have a lawyer, you must ask them before your court date whether or not you need to go to court. If you do not have a lawyer, you must go to court whenever your case is being mentioned. I'll discuss the first mention. Do you need to go to court? The answer to this question depends on 1. How you've been charged with the offence. For example, did police issue you a notice to appear? Or did they arrest you and charge you at the watch house and give you bail. 2, if you have a lawyer representing you. If police issued you a notice to appear, then you must go to court. You must go to court even if you have a lawyer representing you. If you've been charged at the watch house and police gave you bail, that is, they got you to sign a bail undertaking, then if you do not have a lawyer, you must go to court. If you don't go to court, a warrant will likely be issued for your arrest. If you have a lawyer and they are going to go to court to appear at the mention for you, then it is likely you will not need to go to court. When a person is already on bail, it's common practice that a lawyer can generally ask the magistrate to excuse their client's appearance. If you have a lawyer, you must check with them if you need to go to court for the first mention of your case. Now, I'll discuss bail. Persons charged with criminal offences are remanded in custody. That is, they're either sent to prison or held in a watch house, or they're given bail. If you were arrested and police gave you bail, then bail should not be an issue at your first court mention. However, if police gave you a notice to appear, bail will be discussed. When you appear in court for the first time, there are 3 things regarding bail that might potentially happen. 1, the prosecution does not object to you being granted bail. It does not ask the magistrate to make any specific bail conditions. 2, the prosecution does not object to you being granted bail, but they want the magistrate to make some specific bail conditions. 3, the prosecution objects to you being granted bail and wants you to be remanded in custody, that is, kept in prison while your case is being determined. This is rare because if police wanted you in custody, then they would have arrested you and kept you in custody. What happens if the prosecutor asks the magistrate to refuse you bail? If the police do not want to give you bail, they'll arrest you and keep you in custody until your first court appearance. If you're remanded in custody at the time of your first court appearance, the magistrate will probably ask if you want to make a bail application. Before you decide if you'll make it a bail application, you need to make sure you're prepared for it and have all the information you need. You only get one chance in the Magistrates Court to apply for bail. If the magistrate refuses giving you bail, then you can only apply for bail a second time if you can show a change in your circumstances since the first time you made the bail application. If you cannot show a change in your circumstances, you'll waste your time in applying for bail. It's much easier to make an application for bail in the Supreme Court of Queensland because you don't need to show any change in your circumstances when applying for bail in the Supreme Court. Signing the bail undertaking. If the magistrate gives you bail, you'll need to sign the bail undertaking before you leave the courthouse. Once you leave the courtroom, you'll generally need to go to the court registry and wait for your bail undertaking. The clerk of the court will call your name out to say your undertaking is ready for you to sign. If you do not sign your bail undertaking before you're leaving the courthouse, a warrant may be issued for your arrest. I'll talk about the options at your first court mention. I strongly recommend you get legal advice before your first court mention so you're fully aware of all your options. When you go to court for the first mention, there are generally a few options open to you, which I'm going to discuss to you now. The first one is you can plead guilty to the charge and be sentenced. You can tell the magistrate you intend on pleading guilty to the charge, but you want your sentence hearing adjourned to another court date. You may ask the magistrate for an adjournment so you can get some legal advice. You may ask the magistrate for an adjournment so you can case conference with the prosecution. You may ask the magistrate for an adjournment because you're waiting for the prosecution to give you some material you have asked for. You may ask the magistrate to list your matter for trial. And in the Magistrates Court, this is often referred to as a summary hearing, not as a trial. The magistrate will then call the witness to the stand and ask the witness to give you some material you have asked for. You may ask the magistrate to list your matter for trial. And in the Magistrates Court, this is often referred to as a summary hearing, not as a trial. but it is a trial. I'll now discuss option 1, that is, pleading guilty to the charge and being sentenced. If you go to court and you do not already have a copy of the QP9 court brief, the prosecutor should have a copy to give you. The QP9 court brief will tell you the offence you're charged with, and it'll give you a summary of the facts the police allege that makes up the offence. Now, if you want to accept, that is, you agree to the facts and the charge as they're alleged in the QP9 court brief, you can enter a plea of guilty to the charge and be sentenced by the magistrate. This means your sentence hearing will take place straight away, and the magistrate will tell you the penalty they are giving you. If you tell the magistrate you intend on pleading guilty to the charge, but you want your sentence hearing to be adjourned to another court date. If you want to accept, that is, you agree to the facts and the charge as alleged in the QP9 court brief, but you're not ready for your sentence hearing, you can ask the magistrate for an adjournment. You should tell the magistrate you intend on pleading guilty to the charge at the next court date. Now, the reason it's important to do that is so that the magistrate can record on the file that you told them on that date that you're intending on pleading guilty. The reason why this is important is because when you turn up at your sentence hearing, you want the magistrate sentencing you to know that you told the court that you were pleading guilty and to get a benefit of your plea being an early one. So why would you want your sentence adjourned to another court date? There are various reasons someone may want to adjourn their sentence hearing to another court date in the future. You may want time to get some material for your sentence hearing. Well, you may wonder, what on earth could I get to help my sentence? 1, you may get some character references. You may want some references from persons who know you well. 2, you may want to provide the court with copies of any certificates of achievement. 3, you may want to get a letter from your doctor, psychologist, or psychiatrist explaining any of your current medical conditions, personal circumstances, or if you've been receiving counselling to address your offending. If you adjourn your case to get your material, the material may help reduce the penalty the magistrate imposes. Option 3 is, you can ask the magistrate for an adjournment so you can get legal advice. Like anything in life, it is important to be informed and know all of your options. You can tell the magistrate you're seeking an adjournment so you can get legal advice. I recommend you ask for a 4-week adjournment. This should be enough time to allow your lawyer to get the QP9 court brief from the prosecution and discuss the charge with you. It's better to ask for a longer adjournment than ask for multiple shorter adjournments. The fewer adjournments you ask for, the better it is in the long run for you. Option 4 was asking the magistrate for an adjournment so you can case conference with the prosecution. You may ask the magistrate to adjourn your case to another date so you can case conference with the prosecution. You may wonder, what is case conferencing? Well, Magistrates Court practice directions define case conferencing to mean negotiations, including discussions as to whether or not negotiations will take place, between prosecutions and defence to discuss issues in dispute in order to bring about an early resolution to proceedings, which negotiations may result in, but are not limited to the amendment, substitution or withdrawal of charges, and or agreement as to a factual basis of sentence and submissions on the sentence range. Now, when you negotiate with the prosecution, you may ask them to do various things. 1, you may ask them to amend a charge. 2, you may ask them to substitute the charge before the court with a different charge. 3, you may discontinue the charge. Or 4, you may ask them to agree to a factual basis for sentence. Option 5 was asking the magistrate for an adjournment because you're waiting for the prosecution to give you witness statements and or exhibits for your case. You may ask the prosecution to disclose, and when I say disclose, I just mean give you, and that you may ask them to disclose specific witness statements or exhibits. The prosecution will need time for the police to get the statements and or exhibits so they can give them to you. The adjournment will allow the prosecution time to get you the material you want and time for you to look at it In some situations, you may want to see some of the evidence before deciding what you want to do. For example, police may allege there is CCTV footage showing you committed the offence. You may want to see the footage before you decide to plead guilty to make sure it is you on the footage. Option 6 is to list your case for summary trial. As I said, in the Magistrates Court, this is often referred to as a summary hearing. I can't stress enough, get legal advice before you list your case for trial. You can ask the court to list your case for trial, summary hearing. There are risks of going to trial. If you go to trial and lose, you'll most likely get a higher penalty than had you pleaded guilty. If you're at risk of serving time in prison, then if you lose at trial, you'll spend longer in jail than had you pleaded guilty. The courts encourage defendants to plead guilty by reducing penalties because they recognise the defendant's cooperation with the administration of justice. The law says the court must consider a defendant's guilty plea, and it may reduce the sentence that would have been imposed had a plea not been entered. If you do list for trial, your matter should be listed for trial at least 49 days, that's about 7 weeks from when it's listed. The full brief of evidence must be available by the prosecution to you within 35 days, that's about 5 weeks of your matter being listed for trial, and no less than 14 days, that is 2 weeks from your trial date. Now, if you go past the first court mention and your matter's adjourned to another court date, that'll be a further mention of your case. Once negotiations with the prosecution end and you've got your material you asked for, the court will expect you to enter a plea. That is, whether you're pleading guilty or not guilty. The court will expect you to tell them what you're doing with your case. Now, there's 3 things that can happen at a further mention. The prosecution agrees to discontinue the charge. Or 2, you're ready to plead guilty to the charge and list your case for you to be sentenced. 3, you decide to plead not guilty to the charge and your matter's listed for trial. Now, if the prosecution agree to discontinue the charge, they should tell the magistrate they're offering no evidence for the charge. This means the prosecutor is telling the magistrate they are not presenting any evidence for the charge. If there is no evidence, the magistrate has no choice but discontinue the charge and discharge you. If this happens, it's the end of the matter. You do not have to go back to court for the charge. If you're pleading guilty to the charge, the court may want to sentence you straight away, or they may give you a date for your sentence hearing in the future. The practice directions say your sentence hearing can be adjourned if you have a good reason. Now, if you decide to plead not guilty, and by pleading not guilty, you're going to trial, your trial should be listed at least 49 days, 7 weeks away from when it's listed. The full brief of evidence must be made available for you to collect from the prosecution's office within 35 days, 5 weeks of your case of it being listed. No less than 14 days, that's 2 weeks from your trial date. Now, in the Magistrates Court, there's an onus on you to collect your brief from the prosecution. Do not expect them to post it to you because they don't. Now, what's a full brief of evidence? A full brief of evidence is defined in a practice direction, and it means a brief which contains copies of signed statements of witnesses and exhibits upon which the prosecution proposes to rely on in the proceeding, and all things if the prosecution other than things the disclosure of which would be unlawful or contrary to public interest that would tend to help your case. The full brief of evidence should contain all the evidence the prosecution intends to rely upon in proving the case against you. That is, all the evidence they need to prove the charge against you.